Senator Wallace.
Thank you, Chair, and thank you, Mr. Saint-Denis. It's good to have you here today. A couple of questions. As I read Bill C-15, the intention, I think, should be obvious that Bill C-15 is attempting to enhance the safety and security of Canadians. It's attempting to deal with the scourge of drugs, which exists, unfortunately, to too great an extent in this country, in particular, zeroing in on organized crime and all of the problems that can bring to society. But against that backdrop, an issue that's come up, and I must say since Bill C-15 has been publicized, I know I've received messages from people that have various concerns. And what I've seemed to take from some of those messages is that there's confusion. The public seems to be confused. And in particular, I'm looking at the proposed new mandatory sentences that would be included within the Schedule II drugs. And in particular, the penalties, the minimum penalties that would exist for the production of marijuana, cannabis, that would cover 5 plants or more. And the impression I'm left with, or the questions that are being posed, is that somehow Bill C-15 relates to possession of those drugs, as opposed to my understanding that it relates to the production for the purpose of trafficking and trafficking in a broader sense, and as well exportation and importation. But the fact is that Bill C-15 is not dealing with possession. Rather, it's production, in particular, production for the purpose of trafficking. So my question for you, what does it take, what proof, what evidence, type of evidence is needed to prove that production of 5 or more plants would be for the purpose of trafficking? What does it take to constitute trafficking in the context of those 5 or more plants?
Well, you would need the number of plants. That's the easy part. Mm-hmm. The more difficult part is what you would want to call perhaps a gathering of indicia, the result of which would lead one to conclude that there was trafficking. And by that I mean, for instance, if the individual has a number of baggies that are filled with marijuana, cannabis marijuana, if the individual has what looks to be a client list, if he has had prior convictions for trafficking. So there are a number of various sort of events or manifestations or indicia that could lead someone to conclude that the production is for the purpose of trafficking. But it is an onus that is on the Crown to prove. It's not one that is presumptive.
So simply someone being in the possession of 5 or more plants would not necessarily constitute trafficking and would not be impacted by Bill C-15. Is that correct?
Well, not by the minimum penalties. If all it is the individual is growing 5 or more plants, mm-hmm. less than 200 or less,
yes.
But more than 5, mm-hmm. Then if there's no demonstration of trafficking, or if you can't demonstrate the purpose, then it's straight production and there's no minimum penalty. But there's still an offense. And that's punishable by presently 7 years.
But to attract the minimum penalties under C-15, it would have to be proven by the Crown that production was for the purpose of trafficking.
That's correct.
The Crown would have to adduce that evidence to convince the court.
By the way, another method of proof is through wiretap evidence or through testimony. There are, I guess, many ways of achieving that proof. But it has to be done. So, yes, you're correct in your...
Yeah, well, thank you for clarifying that. It's very, very important to a number of people. One further question. The medical use of marijuana and cannabis is approved in certain circumstances in this country. There's a process, an approval process, it's a licensing process, as I understand it, that enables people, those that need marijuana and cannabis for those approved medical purposes, to use it. How, if in any way, does Bill C-15 impact upon that legal right, present legal right to use marijuana and cannabis?
Well, it should not. It does not purport to interfere with the regulatory process of medical marijuana. Patients who are referred by their doctors apply to Health Canada, and if they get their permit to possess, or if they get a permit to grow, they are exempted from the application of this and the CDSA as far as the marijuana goes.
Well, again, thank you for clarifying that, because, again, I sense from some of the feedback that I've received, there is confusion in the public over that issue, but I think you've clarified it very well. Thank you.
Thank you, sir. Senator Milne.
Chair, I too have been getting emails from users of medical marijuana who are greatly concerned that they're going to be caught by this five or more who are growing their own marijuana. And they're greatly concerned about being caught with this 5 or more or less than 201. Is there some way that the government can set their mind at ease? Because I don't think what you have said in this room is going to get out there to these people very quickly.
Well, I think, though, it's important to make a distinction between those who use marijuana for medical purposes through the regulatory process and those who self-medicate. Those who self-medicate without accessing the permit,
are going to be caught by this.
They will be caught. They are contravening the provisions of the CDSA and would be caught by this. So those individuals we can't help. As for the individuals
other than
who
advising them to go to their doctor.
Yes. And those who go through the regulatory process, if this bill comes into force, when this bill comes, your choice, it's in your hands, not mine. Then I have to believe that the media will report this, and that more accurate information will be put out there. Plus, there will the new legislation will be put on the Justice website and so on and so forth.